Hey, Mr. and Mrs. Smith, welcome back. I'm glad to see you. Today I wanted to talk to you a little bit about estate planning, some estate planning issues. I just want to make sure that you understand I'm not an attorney, I'm not representing you. So these are just some ideas and a few guidelines that I just want to go through and provide so that when you actually go see an estate planning attorney, that you kind of know what questions to ask, and you know what direction you need to be going. I know that you have wills currently. Um, I think they were sweetheart wills, where basically each of you, if one of you were to pass away, everything went to the other spouse. I think at the time that was probably fine. I think you're definitely going to need to update your wills. I think that's probably one of the first things you need to do. I think we discussed a little bit in some of our meetings the difference between community property and separate property. I just wanted to kind of rehash that a little bit. So with community property, that's yours. If one of you were to pass away, the other spouse is entitled to the community property of the other spouse. Separate property works a little bit different. In Texas, there's actually a statute or a constitutional provision that determines that separate property passes differently. So if it's not taken care of in the will, you might get some results that are unintended. So I would encourage you to go talk to an estate planning attorney, get your wills updated. The other issue is the trust. I know you sent us a letter mentioning that you wanted to have the ranch stay in the family. I think one of the best vehicles for that is going to be a trust. There are a couple ways to do it. You can do it while you're living, or you can do it through your will. The inter vivos trust is a trust that you make while you're alive. So I mean, you draft the trust, you fund it somehow, so you can deed the ranch to the trust, and the trust owns the ranch. Um, I think for your sake or for your needs, a testamentary trust is fine. Basically, you'll put a provision in the will that establishes a trust, and when one or both of you pass away, the trust would be funded with either income or the ranch. So I know you wanted Michael to be able to manage the ranch, which would be fine. The income that comes from the $100,000 that would be coming from the ranch can go to Lizzie. The nice thing about trusts is you can write them however you want. So if you want Lizzie not to get money until a certain age, if you want Lizzie to only get money for education, if you want to limit the type of spending that she can have, that's totally up to you. It's completely at your discretion. You would just need to talk to the estate planning lawyer and say, this is, we want X, Y, and Z. So those are the two big things. A few others are, powers of attorney, living wills, or advance directive to your physicians. Starting with an advance directive, these are important. A lot of these forms can be done on your own. These are available online. I've included some of these forms in your plan just so you can kind of get a general idea of what they do. With the advance directive or the living will, it basically says, this is the type of treatment I want. So, if you suffer from dementia, or if you're incapacitated, if you have a terminal illness, you can say, hey, I don't want to receive life-sustaining treatment. If you're in a coma, you can say, I don't want to be force-fed. I don't want to be put on an intubator. I don't want to have tubes. Of course, that's at your discretion as well, but it gives your physician an idea of what you do and don't want as treatment. Um, Looking to durable power of attorney and medical power of attorney. Durable power, both of them assign an agent. One is for property, one is for medical treatment. So durable power of attorney, because you have each other right now, it might not be necessary, but if something were to happen to either one of you, you could assign Michael or someone in your family as an agent to basically manage your property. And the same thing with your medical care. You can assign an agent to help make medical decisions in case you can't make those decisions. The HIPAA release form, just make sure that if something were to happen, that your kids would have access to your health information, and then the self-designation of guardianship, which we've discussed a little bit as well. If one of you are incapacitated, it basically says there's a statutory scheme that decides who's going to be appointed the guardian. So there's an order of priority. The spouse is number one, but this basically says to the court, if there's someone that you just absolutely don't want to be a guardian, you can note that in the document, and if there's someone that you would prefer, you can make that notation as well. Again, this is all just we just want to give you a general idea of what's going on so that when you do speak to your estate planning lawyer that you have some direction, you have a little bit of guidance. So if you have any other questions, feel free to ask. Thanks for stopping in.